the other problems. So I hope this matter can be discussed in the House Committee instead of hastily proceed to the scrutiny in the next stage here. Mr. Elvin Yang. Thank you, Madam Deputy. I'm very happy that our President allowed this in a very smart decision so that we can have a very enlightening debate on the relevant issues. No, Madam Deputy, we are not talking about the clauses in the bill, but rather whether we should, as suggested by Mr. Chu Hoi-tek's motion, refer the matter to the House Committee with the very intense, attentive listening on the part of Mr. Paul Chair. I would certainly heed Madam Deputy's very discerning observations and complete my speech here. Mr. Chen Chen-ying is here. I don't think anyone should dare to venture into the territory of banking business. But when our colleagues talk about the two cases in 1982 and 85, we were not able to give you the necessary details. Well, let's look at the three readings that we did in 1985 for the OCTB case, because it was about another bank. So I don't think you would rule that it's irrelevant here. Well, I think you should speak on the motion not to refer the bill to the House Committee. As for the past precedents cases, other members have already spoken on them. Well, if you want to advance an argument, you want to have something in support of your reasoning. I don't think we shouldn't just jump to the conclusion that I support or do not support something. Well, this is not actually what the members here have been doing, and this is not in line with our tradition. We are talking about the OCTB in 1985. The bank was taken over. I think we have heard about this a number of times already. Thank you for your reminder, for President Chair's reminder. Maybe next time, it would be better if Mr. Chair can point out to Madam Deputy when was the remark last mentioned. Well, he has been listening very attentively. Maybe he can also refer to the other examples quoted by other members and remind me of the same. I will be more alert to such matters. Well, there was a bank run on the Overseas Trust Bank. In 1985, it was a ban. In 2017, we're also talking about the banking ordinance. So why don't we consider it carefully? Mr. Chair, this is the crux of the matter, whether we should support Mr. Chu's motion. Time has changed. In 1985, the banking system did not enjoy very good protection and coverage. And now, since the financial tsunami in 2009, 2008, many governments have put in place institutional safeguards for their banking industry so that the past mistakes will not be repeated. We should repeat such mistakes, Mr. Chair. Hong Kong is one of the 20 members of the relevant committee. We should look carefully as regards what we should do and what we shouldn't do. And the UK spent $17 billion to protect their banks. The Basel Committee is important. You don't need to explain what the Basel Committee is about. You should explore what other arguments you may have on the motion. Thank you for your reminder. This is the first formal reminder to you. We have to look at the financial stability of our banking system. This motion would affect in the message we send out and the image we conveyed to other people in respect of our banking system credibility. If we agree with Mr. Chu's motion, we'll continue with the second reading, the committee stage, and then there will be the third reading. Of course, we can do that, but we haven't done any consultation. It can be up to the government. It can be the government may make the decision. The banks do not have strong views. Mr. Stephen Ho, actually, this has been mentioned by another member. This is a fact. The fact that there's been no consultation has been referred to for more than once by other members. Thank you, Mr. Stephen Ho, for listening very carefully to my speech. I understand all the members here are very attentive, and I think we should encourage other members to do the same. Actually, this point about members being very attentive has also been mentioned. Mr. Alvin Young, Madam Deputy, if members are very attentive, then I don't think this has not been mentioned before. This is really appreciated. And with all the members of the DAB here, no one has gone out. Well, you have been talking about attentive listening, and please don't go round and round in circles. Please return to the subject on hand. I must state this observation. Through this debate, we can really promote harmony in the Council. I felt the warmth of pro-establishment members who are very concerned about the content of my speech. I think Mr. Young is digressing. It's already 7 minutes and 48 seconds since you started. You talk about if we don't do this, our reputation will be affected. And then you also talk about some personal feelings. I hope you can cut down on such references. Dr. Fernando Chia, any point of order? Why is the clock still running when I'm speaking? The clock moves on means that the world will move on irrespective of one's subjective wishes. I was talking about our status as an international financial center. Apart from the banks or the banking system, other things are important. But banks provide support to all other trades and industries, so we should give more support to our banks. So we should return to this subject, and that is whether in respect of this motion, should the bill be referred to the House Committee, and then should we set up a Bills Committee to deal with it? That has to do with our core value. That is to say, efficiency. Banks are an important part of the financial sector. Should we deal with this bill in one go today? That has to do with efficiency. So we have to consider whether efficiency is more important than close scrutiny. Well, whether we need to scrutinize the bill closely has been a point mentioned by other members, and they have referred to many clauses in the bill. So please return to your arguments. I have not referred to any specific clauses in order not to be repetitive. I support. I'm just trying to say why I support Mr. Chi's motion. So let's continue. Whether we should have higher efficiency or we should scrutinize the bill closely, but is the close scrutiny tantamount to the lack of efficiency? No, not necessarily. If members find the clauses agreeable, the Bills Committee will not need to spend a lot of time, and we can handle the process very quickly. For this bill, is this bill that can be processed very quickly, so that on the one hand we can have a very careful scrutiny and also our wish to be efficient can be satisfied? I think Mr. Chen Ying, who is going to speak on this one, will be able to give us a lot of insight. But before Mr. Chen speaks, I think members should explain why we are going to live up to the expectation for efficiency, if this is referred to a Bills Committee. Efficiency is not an excuse for enacting a bill as quickly as possible. For this point about efficiency and speed has been mentioned. Please say something. Please mention some new arguments, or I rule that you are being repetitive. I want to make a clarification here. You are saying that we cannot clarify other members' remarks, but members have the freedom to speak. Although you may say that the arguments look similar, I cannot repeat what I've said.
However, not to repeat the argument of another member, I don't think this is what is set out in the rules of procedure, unless you can point us out. You can point out what paragraph of the ROP it is. Point of order. I'd like to have a quorum call, please. Members, please return to your seats. Meeting will be resumed. Mr. Alvin Young, please wait a moment. I have to answer Mr. Kenneth Leung. According to 45(1), the President, the Chairman of a Committee of the whole Council, or the Chairman of any standing or select committee, after having called the attention of the Council or the Committee to the conduct of a member who persists in irrelevance or tedious repetition of his own or other members' arguments in the debate, may direct him to discontinue his speech. So I have acted according to ROP 45(1) in order to remind members not to repeat his own or other members' arguments. In exercising the powers as President, I did not ask members to stop in the first instance of repetition. Like with Honorable Alvin Young, I waited for the second time before I reminded him that he was repeating the points of other members. And since members are speaking for the first time, we allowed certain discretionary allowance. So we'll continue. Mr. Alvin Young. I'd like to clarify. It says persist in irrelevance or tedious repetition. You must be satisfied that all three elements are present. As you know, in any debate, the points would just be the same 3 or 4 points. How can you say a simple repetition will cause a member to have to stop? As you know, whether it is members supporting or arguing against a motion, there would always be just 3 or 4 points. But every member can have his own style in presenting the points. Therefore, you must allow for both elements of persistence and tedious repetition before you stop a member. Can you clarify that point? Mr. Leung, my ruling is in accordance with the powers given to me by the ROP and the convention of this Council. As you pointed out, some of the arrangements in the ROP may not be reasonable, but 45(1) states clearly that as the President, if a member persists in irrelevance or tedious repetition of his own or other members' arguments in the debate, and after having called the attention of the member to this situation, I may direct him to discontinue his speech. If you want to debate the enforcement of the ROP, I would ask Mr. Leung to do so after the meeting with the legal advisor or on other occasions. Mr. Young, please continue.
And I wish to complete the rest of my speech in another official language of the city, that is in English. And of course, as the Honourable Mr. Kenneth Leung mentioned earlier, it is very difficult for any member to have any new and creative arguments when it comes to a very fine point, especially when we come to such a technical ordinance or such technical bill. And of course, Madam President, I just wish to stress on one very important point. That is on recovery and resolution planning. That is a duty under the agreement, an international agreement that is on Hong Kong's, that is to Hong Kong's interest. And Hong Kong has to demonstrate that as an international financial city, we have to be as speedy as possible. And that is one of the main reasons why the Civic Party today is not in line with the Honourable Pt2, that is we are in the position that we should have this bill to be discussed in a Bills Committee in the future. Of course, I have to stress that we wish that such bill could be done and the discussions could be done in a very speedy and effective way and efficient way. But of course, returning to the importance under the international treaty, the jurisdictions should require that the firm's senior management be responsible for providing the necessary input.
Sorry, Mr. Young, please wait. Mr. Holden Chow, what is the point of order?
And speedy has been repeated.
Mr. Alvin Young, please come to a new argument. You mentioned the responsibilities under the international agreement. I think other members have already mentioned it. Please come back.
To have the experience.
提出新嘅論點係
Mr. Ibrahim Shak.
That we do have a right to free speech, and in 45(1), it is categorically say that if it is irrelevant or tedious repetition, when we talk about a viewpoint, if we repeat the viewpoint that is not irrelevant or tedious, he can speak. So why do we have to create all this mumbo and jumbo that they are out of order? We're wasting a lot of time. If they want to speak within the 15 minutes, and if that is relevant, whether that have been repeated or not, it's not a tediousness as such. Excuse me, Madam President.
石禮謙議員，請你坐低。呢一個場合呢，不是
Mr. Ibrahim Shak, please sit down. This is not a forum for debating the enforcement of the ROP. I have already said that I acted in 45(1). If a member, I am not saying that I disagree with your ruling, but if a member is affecting the right of other members to speak, I must protect that right. Mr. Shak, please sit down, and Mr. Young, please continue.
For the Honourable Abraham Shak's observation on the rules of procedure, and of course, may I just make one very short remark that I was quite excited to hear what the Honourable Holden Chow, when he first said objection in this chamber, knowing that we are not in a courtroom. Madam, with only 1 minute left in my speech, I just wish to stress on something highly important and relevant and totally not tedious to the matter. That is, Madam, the banking system is the core of Hong Kong, and we are all responsible for a healthy and modern banking system. And no matter what, I wish to put on record that I trust, regardless of our political belief, every member here sitting in chamber today are of the interest and with the good intention to improve the banking system of Hong Kong and to make Hong Kong a truly international financial center. Hence, regardless of the result of of the Honourable Ediju's resolution, I trust that we will do our very best when it comes to the Bills Committee, and every member who will be in the Bills Committee will do their best and serve Hong Kong to the fullest. And I rest my case.
Ms. Tanya Chan. Thank you, Madam Deputy. My party leader is sitting next to me, and this is the Civic Party, and he was saying how important the financial sector is to Hong Kong. What I'm going to speak about is that in fact the government website is really very effective, and now I already have a printout of the Secretary for Financial Services and the Treasury speech, and I have also dug up some information with regard to this bill to explain and deliberate on why the Civic Party cannot support the motion by Mr. Eddie Chu. As I said, the financial sector contributes to our GDP. Earlier on this month, Mr. Paul Chan said that it contributes to 18% of our GDP. Therefore, whether we can have a healthy banking sector that complies with the improvement measures stated internationally, well, that is something very relevant. On the one hand, the banking sector would like to comply with international requirements, but on the other hand, they have their worries. And this is not just from me. And we are talking about a balancing act. That is why we think we should set up a Bills Committee on this bill. At hand, I have this Legislative Council paper, the banking sector was referring to implementing Basel III rules vis-à-vis the competition between Hong Kong's banking system and other banking systems. And this matter of competitiveness has everything to do with this bill. Now, I shouldn't use the word urgency because I might be accused of repetition, but I like to talk about timing because in the past, well, I am not going to cite the two examples in the 1980s, but in the past, the administration did something with the Basel requirements and the banking ordinance was amended, and even the regulations were amended in 2012 and 2014. There were exercises to do so. And the commonality on those two occasions was that both happened in October, because every time before an imminent implementation of the new rules, or 1 or 2 months before that, the administration would come to the Legislative Council to ask for amendments. Again, this time around, it is October, and all of a sudden, we have this Banking Amendment Bill 2017. It happened already in 2012 and 2014. And therefore, I had to look up what happened in 2012 and 2014, whether we actually made it in time to comply with international obligations. And so I dug up the files to see whether the timing was appropriate. As I said, if we go too fast, then internationally, Hong Kong might be said that there would be too much regulation within the banking or financial services. This is what the banking sector said. And if we were too lax in our rules, we might be taken to task. And this is important, Madam Deputy, because as a member city, we have to respond to the aspirations of the banking sector. As I said, they have this worry. If we are too advanced in compliance, then other banking sectors may overtake us. Ms. Tanya Chan, we have this debate, and that is whether we support Mr. Eddie Chu's motion not to refer the bill to the House Committee. In fact, the first reading of the bill has been completed, and it is now a debate on whether we should refer it to the Bills Committee or whether we should go directly into a scrutiny of the bill. Madam Deputy, we have been councillors for a long time, and if it is referred to the House Committee, then you, your good self, as chairman of the House Committee, would ask members whether a Bills Committee would be set up, and then we can have scrutiny at the Bills Committee, or we will decide whether there should be public hearings. But this time around, actually, Madam Deputy, I did not want to repeat the procedure mentioned by other members, and that is why I went directly into the content. But since you asked the question, I had to detail the different steps again. And of course, we then would be given some time for scrutiny. On the 1st of January 2018, it would be the deadline for us to comply with certain international requirements, and they are not ordinary requirements. You see, I have so much in front of me. It is because in October 2017, they have the Bank of International Settlement. And this is the BCBS requirement on us, and that is the Basel Committee on Banking Supervision. It is about the rules and regulations in the member cities and countries. This is the 13th report. I looked at the report because I want to know whether we are lagging far behind, or on the contrary, whether we are walking too fast so we are not competitive. And we must know the international obligations. Ms. Chan, I am reminding you of the second time. For the second time, you are repeating our obligations under the international agreement. But as I said, this is a debate on whether the bill should be referred to the House Committee. Why don't you just concentrate on that instead of concentrating on the requirements? Madam Deputy, I don't want to repeat what my colleagues have said. As I said, having been a councillor for so long, Mr. Eddie Chu is saying whether we should directly go into the scrutiny. And if we are going to go to the House Committee, and then we have to set up a Bills Committee, and then we'll
have to conduct public hearings. Is that appropriate?
Are we going to overrun the entire process? Is here. The world is watching on a certain element of the new system. If we fail, if we cannot do it in good time, we will be given a black mark. And that is to say, if we fail to take any action, you're given this mark. Hong Kong is in competition with Singapore, and this table lists out all the members of the committee. And this is very important for me in deciding whether to support Mr. G's motion and also the position to be adopted by the Civic Party. China has got some of the marks put here, has been given some marks. Our financial sector is in keen competition with Singapore. We cut the tax rates for the aircraft leasing. I won't digress. Otherwise, you say that I'm not speaking on the subject. For Singapore, they have got everything clear. They've got all the green marks, meaning that they have all the necessary action taken. But if we fail to comply, and if we set up a Bills Committee, we may have a public hearing. We're given these are black marks. Singapore, EU, and the US. Well, EU and Singapore have achieved full compliance, but not the US, which is the most powerful financial house in the world. The industry is also afraid that if we move too quickly, our competitive edge will be affected. The Secretary said in the last paragraph of his speech, he would like this Council to enact the bill, to pass the bill quickly so that we can implement the Basel-related standards and enhance Hong Kong's status as an international financial center and our credibility as a member of the Basel Committee. So we have to take into consideration our credibility. We're not doing very bad so far. In 2013, 2014, in respect of the implementation of Basel standards and measures, in relation to the capital regulations, we have been subject to international scrutiny on whether we were able to comply with the two standards under Basel III. There were two checks, and we passed both checks. Yes, please return to the subject. I'm always on the subject of this motion, whether it's about credibility and responsibility and efficiency and the need to strike a balance. This is very important. I need to consider in 2015 and in the past, we did quite well. As I told the President in October 2012 and October 2014, there were banking amendments bills passed in Hong Kong. So we still have time. So we should refer the matter to the Bills Committee, so that to the House Committee, so that a Bills Committee can be set up. If this is done, I will certainly join the Bills Committee. Maybe I can also say why we should set up a Bills Committee, why I should act with prudence. In terms of the amendment, as some members have said, there are a number of amendments in the banking ordinance, in the banking amendment bill. They are going to introduce a new provisions on financial exposure limits. This is going to be a new part in the law. And as a result, the MA would enjoy some new powers. And the new powers are really new, and those powers would result in criminal liabilities. What the power of the MA will come from the banking ordinance. The MA is very powerful. I'm not just talking about recovery plan. On the question of financial exposure limit, it's going to be a new part of the law, and such provisions carry criminal liabilities, and the penalty is quite heavy. For example, 81C. Criminal sanctions is imposed, and for other clauses there are other penalties. Ms. Chan, other members have already pointed out that in the new clauses there are new contents, and therefore more time should be spent on the scrutiny. I don't think this is tedious. I don't think it's a tedious reputation or irrelevant reputation, as mentioned by Mr. Abraham Shek. That is under Rule 45(1). We are talking about irrelevant or tedious and tedious repetition. So if you want to give me further reminders, please tell me what I've said is irrelevant or is tedious repetition. I don't think criminal offense or liability is anything but tedious. Therefore, we should not rush through the matter. I certainly agree that the matter should be referred to the House Committee so that we can set up a Bills Committee, and let's do it a very thorough examination. And the public would like to get a good piece of law enacted that would keep us in line with international obligations. Well, Ms. Tanya Chan has asked me to have regard to Rule 45(1). As I've said, the President, the Chairman of a committee of the whole Council, or the Chairman of any standing or select committee, after having called the attention of the Council or the committee to the conduct of a member who persists in irrelevance or tedious repetition of his own or other members' arguments in the debate, may direct him to discontinue his speech. So it's or. It's linked up by or. You may not totally agree with this particular rule, but I base my reminder as under 45(1). You just mentioned that there's a repetition, but 45(1) is not just about repetitions. It's about irrelevance or tedious repetition. You must understand that your power comes from the rules of procedure. If you exceed the rules, the scope of the rules, then you will be acting ultra vires. I understand members may have difference in opinion about the rules of procedure. If we want to discuss this, we should do it after the meeting. A point of order. Madam Deputy, I would like to ask you to explain what is regarded as irrelevance or tedious repetition. Members sometimes have similar or identical views. When an argument is mentioned by one member, you are saying that another member can say I echo that. I share that view. If that's the case, if that's the way you interpret Rule 45(1), this council will be very much restricted. And that is, if I repeat another member's argument or reasoning, I will be in violation of Rule 45(1). I would like to respond to Dr. Zhang's remarks once again. This is not a forum for a debate on the rules of procedure. I have had regard to Rule 45(1), and I've tried to strike a balance between members' freedom to make speeches and the problem with repetitive arguments. You will understand that I would not ask the member to discontinue his or her speech right away. I will just point out that he or she has been making repetitions. Rule 45(1) talks about a member who persists in irrelevance or tedious repetition of his own or other members' arguments. So it only covers tedious repetition. Mr. Chen Ji-Chin, do you want to raise a point of order? Mr. Chen Ji-Chin, she accuses me of misconduct. Well, sometimes members have very pointed arguments against another member. That has happened. Please raise your point of order. In the past, if a member repeats some arguments in different matches, so if there are 10 points for and 10 points, or 10 arguments for and 10 arguments against the collocation proposal, then are you saying that 20 members should speak and then that's it? Well, I have already said that you may not agree with all the rules in the rules of procedure, but the 45(1) authorizes me to discontinue a member's speech. But I want to safeguard members' right to speak as well as the order of the meeting. So if it's the first speech, I would allow members to put forth his arguments for and against the motion. Ms. Tanya Chen, if you want to argue about Rule 45(1), I cannot allow that. No, not about that. I hope that in due course you would apply the same standards to other members or the president. Mr. Chen Ying, I thank all the members for saying that they are expecting my speech. The Secretary for Financial Services and the Treasury spoke on the resumption of the second reading of the bill, and he said very clearly that the bill would enable our banking system to comply with the latest regulation system internationally. But because of the time and space of this council, it has become the subject of filibustering. If this is referred to the House Committee, I think generally speaking, a Bills Committee will be formed, and there will be 1 or 2 Bills Committee meetings, because this is rather technical, and then the Bills Committee can have a focused discussions. Whether there are CSAs or no CSAs, the matter will be referred back to the Council for the resumption of this second reading debate, and then the bill will be passed after receiving the third reading. I believe members would like to scrutinize the bill carefully. If this bill is proceeded with immediately, then there will be no time for members to get prepared. But when the President ordered a break and to consider the motion. Many members asked me what this bill was about because, and then I think you should. Many people suggested that I will welcome Mr. Chu's motion and let this bill pass quickly.
But I don't think so, because like Mr. Eddie Chu said, this bill attracts a lot of attention and we should follow the established practice in scrutinizing the bill carefully. And I also noted that a number of members who spoke just now didn't really support Mr. Eddie Chu's motion. So to save our valuable time, may I suggest that any questions directed at me or other members, and also questions that, despite my best efforts, are not quite comprehensible, should be raised at the Bills Committee, and that is why I don't support this motion. Dr. Fernando Cheung. Well, Mr. Ronald Chan represents the banking sector, and after he had spoken, I think that I have so much on my shoulders speaking about the Banking Amendment Bill. In particular, I'm not familiar with the banking business, but it's not really true to say that I am totally unrelated to Mr. Ronald Chan's work. In fact, a few weeks ago, we had a meeting together. We met with the banking sector's representatives on how we can make it more convenient for disabled clients. So Mr. Eddie Chu just moved a motion to oppose the second reading of the bill being adjourned. And this bill seeks to make provisions for the recovery plan of authorized institutions, and also in relation to the limits, and the monetary authority will be empowered to set limitations on financial exposures. According to the SAR government, what they seek to do is to, well, Dr. Fernando Cheung, is it that you are carrying a mobile phone with you? There is interference. No, I have it with me. I will put it away. The bill seeks to align ourselves with international regulatory standards to enhance our responsiveness. And of course, we are talking about the Basel Committee on Banking Supervision, BCBS, and to make our financial institutions more prepared to respond to risk events. We're talking about enhancing their resilience. Mr. Chu's motion seeks to prevent the adjournment of the second reading, and that we should proceed with the second reading right away, followed by the third reading and the voting process. And it all hinges on the urgency of the issue. Mr. Eddie Chu just now said that since the government will be moving a non-binding motion on the co-location arrangement, and before that, we also have this bill, that is the Banking Amendment Bill 2017. Of course, the government's mentality must be that the Banking Amendment Bill 2017 is more important than the co-location arrangement motion. Mr. James Lau, the Secretary, just now also said that the government would like to see the passage of the bill as soon as possible. And according to the government spokesman, the bill will revamp our regulatory regime and align our regulatory standards with the international standards, and by doing so, we can enhance the stability of our financial system and bolster our status as an international financial center. So, is it so urgent as to not refer the matter back to the House Committee to decide whether a Bills Committee should be set up for more careful scrutiny of the bill? Let's take a look at the recent risk analyses. For analyses conducted locally, I think the most representative analysis would come from the Hong Kong Monetary Authority. Every half year, the Hong Kong Monetary Authority would publish a report. The latest report was in September 2017. On page 4 of the report, it says that we anticipate that the banking sector in the future will face a series of challenges. Major advanced economies policy diversions will further impact on the major systemic risk facing the financial sector. Dr. Fernando Zhang, I'd like to remind you that you should focus on how the bill should be handled, what procedures should follow, instead of talking about the risks facing our banking sector. But the object of the bill is to enhance the resilience of banks, such that in the face of risk events, banks will be more resilient. Or even before such events arise, how banks should devise their recovery plans. So we should look at economic analyses. And I think since the Hong Kong Monetary Authority has published a recent report and analysis or report on the financial stability of the banking sector, I think that I should just walk you through it. According to the thematic study, the Hong Kong MA has noted the major policy diversions of central banks. Mr. Stephen Ho. I think what Dr. Fernando Zhang just now said had nothing to do with whether the bill should be referred to the House Committee for further consideration. I've already reminded Dr. Zhang not to digress. Well, Mr. President, if you could just ask your good self or other members not to interrupt me, then we would save more time, because I now need to spend more time to explain why my point is relevant to this motion. It has to do with the urgency of the bill. Mr. Pt2 believes that this motion is this amendment bill is so urgent that we should not wait. We should proceed with second reading and third reading and voting. And that is why I need to explain the risks facing the banking sector, whether it is urgent or not. So please don't waste my time. And according to the Hong Kong MA's study, the major advanced economies are tightening up their currency regulations, and the impact may cause huge pressure on the Hong Kong US dollar credit rate. And that's a revelation from the Hong Kong MA. And another important figure in the sector, Mr. Joseph Yam, also published an article on his views. Well, Dr. Fernando Zhang, I need to remind you once again that you should focus on what procedures should follow regarding this bill. You should not relate other people's views. Now, just now you read out the views of the Hong Kong MA. I allowed you to do so, but please do not digress further. The administration has tabled to the Council the Banking Amendment Bill 2017 as a response to the Financial Institution Resolutions Ordinance previously passed in the Council, so as to ensure that the financial institutions are prepared to respond to risk events. And I was just quoting from the Hong Kong MA in relation to the international financial crisis, or Mr. Joseph Yam's views on the matter. 10 years down the road, 10 years after the Asian financial crisis or the financial turmoil, I'd just like to quote from his article in order to see if Mr. Pt2's suggestion is justified. Mr. President, if I'm not allowed to repeat other people's point of view. Of course, I don't agree, but at least I'm not repeating anyone's point of view. I was just quoting. Well, I'm not suggesting that this is a repetition. You should, however, focus on the procedural matter of the bill. Please don't digress. Should we vote in favor of Mr. Ju's motion? That is, the reading of the bill should not be adjourned? Or should we vote against it? We need to justify our decision. And the matter hinges on the issue of urgency. As a layman, I need to analyze the matter. And that is why I take part in this debate. I'm quoting from articles, and everything has to do with the object of the bill. Mr. President, I don't understand really why you're interrupting me. I'm talking about the risks facing the banking sector in Hong Kong after the financial crisis, how fragile our sector is. That is in response to Mr. Ju's motion. If you don't like Mr. Joseph Yam, I'll just skip his article. Let's take a look at the world's views. The IMF, the International Monetary Fund, on the 13th of October 2017, in a recent article in Wall Street Journal, published some news. It was said that in the coming few years, a number of banks will be facing issues. But IMF named these banks, including Citigroup, Standard Chartered Bank, Barclays, PLC, and also Deutsche Bank, so on and so forth. Citigroup and Standard Chartered, they also operate in Hong Kong. Their business is very active in Hong Kong. And these banking groups are regarded internationally as banks of systemic importance. I think Mr. Chan, of course, would understand what I mean. Financial institutions of systemic importance means that if they face risks beyond what they can put up with, they may cause local or even global financial crises. And for these financial institutions of systemic importance, if they're unable to take up the risks, what happens is that the governments will need to do something to bail them in, to salvage these financial institutions. And that is why we already have warnings from international organizations such as the IMF, and Mr. Chan surely will know that very rarely would IMF name banks that may be facing a crisis in the coming few years. So when it comes to public interest and the financial risks facing these banks, and if a bail-in from the government is required, ultimately it's the taxpayers' money that will be spent. So if the crises facing financial institutions are so urgent, then maybe Mr. Ju's motion is justified. I don't know how many of you have discussed this motion with Mr. Ronald Chan, but I have just been told by him that there are two parts to this bill. First, it is in relation to the Financial Institution Resolution Ordinance, which we have dealt with. And the second part of the whole initiative is the recovery plan. And the two-part constitutes the requirements of Basel Committee on Banking Standards. In fact, we should have done it in 2015. Regarding the first part. For the second part, the Basel Committee's requirement is 2019. We're still 2 years away from 2019. according to international standards, is it really so urgent that we should pass the bill today? I don't think so. And of course, Mr. Chan would say that it may be too early.
Especially if you look at it from the banking associations or banking sector's perspective, thinking about their own interests, they may think that this is not necessary. But here, at this point, I see that we have very few members in the chamber, and I'd like to ask for a quorum count. The Honorable Fernando Zhang. President, I was saying that Mr. Ronick Chan, speaking from the angle of the sector, said that this was not that urgent because the Basel Committee on Banking Supervision said that this should be done by 2019. But from the angle of the public interest, I don't think this is too early. In fact, we should do it in a timely manner.
We should update our law so that we can comply with the latest international standards. And now the government proposes to give more powers to the MA to come up with subsidiary legislation. The important thing is whether there's any urgency. Mr. Charles Ball. Mr. President, we are now in a discussion of Mr. Eddie G's motion, and his motion is about not referring the Banking Amendment Bill 2017 to the House Committee. The usual practice is that the bill will receive the first and second reading, and then the matter will be referred to the House Committee. Very likely a Bills Committee will be set up. If no one asks for a Bills Committee to be set up, I'll ask for one to be set up. And then there will be amendments to be moved by the government or members. If Mr. Chu's motion is passed today, we'll have no chance to move the amendments. Usually, the government will rely on the scrutiny of the government in relation to the bill. We may identify typos, whether it's Chinese or English, and sometimes the government would thank us for identifying the issues and problems, and the government would move some CSAs to rectify the situation. But if we cannot have the matter referred to the House Committee, well, it's certainly not a good thing. The remaining part of my speech will be, as you have directed, about the procedure to be followed. But I need to also explain why a certain method is preferred in relation to the remaining procedure. This bill, of course, is very important to Hong Kong as a financial center. On the one hand, we're talking about our international obligations. As a leading international financial hub, we bear great responsibility, and the more important that the hub is, the more responsible we should be. Under the G20, the Financial Stability Board was set up, and these international institutions have great expectations about implementing relevant international standards in Hong Kong. And this bill is, of course, very important to the banking sector. I won't go into details. There is the need to pass the bill into law quickly, and on the other hand, we need to examine the bill carefully. This is the crux of the matter before us. If Mr. Chu's motion, that is to say the motion moved by Rule 45(1), is passed, the situation would be less than satisfactory. If a Bills Committee is set up under the House Committee, members will have lots of questions to raise. I have had the chance to look at the clauses. I won't go into the clauses in detail. This is not the right forum. But if you flip it through, there are 27 pages, not counting the index pages. And as Mr. Chen Chun-ying has said the contents are highly technical and we need time to examine the contents. On the other hand, if Mr. Chu's motion is passed, the bill is not referred to the House Committee, and as a result, no Bills Committee is set up, then we will be denied views from the industry or other stakeholders. And many members have said this, not just Mr. Chu. This bill, according to the government, has won the support, general support of the industry, but we shouldn't just be satisfied with this assurance from the government or the fact that this has been discussed at the panel on financial affairs. That's not the usual practice in dealing with a bill like this. So this bill must be referred to the House Committee after the adjournment, like other bills, so that we may consider whether to organize a public hearing. And this bill is called the Banking Amendment Bill. Of course, the banking industry is directly affected, but other industries and individuals may be affected. There are other stakeholders in the financial sector, and we have consumers, investors, and non-banking entities, and also lawyers, accountants may also be indirectly affected. If Mr. Chu's motion is passed, we will not have any opportunity to involve them at all, and the outcome will be most unsatisfactory. As for the contents of the bill, the President has directed that we should not go into details at this stage, but at least we need to know the objective of presenting this bill in the Council. Many members have spoken, but very few have mentioned that this is about the introduction of planning, of recovery planning. When I first read the Chinese version, it was very puzzling, but in English it's easier to understand. It's called recovery planning. As I've said, in 2014, the Financial Stability Board issued a document called Key Attributes of Effective Resolution Regimes for Financial Institutions. In this paper, various jurisdictions are asked to do a number of things. One of them is to provide for recovery planning. Second, resolution planning. And last year, we passed a bill into law on the 6th of June 2016, and that's called the Financial Institutions Resolution Ordinance, which has come into effect in July. And I have been thinking hard about the difference between the two laws, or the two matters. Recovery planning means that there is still a chance to save the bank, but for resolution, it's about tightening up the loose ends when the bank has collapsed. It's about dealing with the aftermath. Then I think people would regard recovery planning as more important, because we don't want to see bank failures, and then we try to deal with the aftermath. But why did we pass the ordinance on resolution, and now we are dealing with the law on recovery planning? Well, I would like to get a chance to ask this question in a Bills Committee set up for this bill. So we are in this discussion on Mr. G's motion. He is suggesting that we proceed to the remaining procedure to deal with the bill today. This is important because when the bank can be saved, when we can still save a bank in trouble, the MA should be empowered to do the recovery planning. So that become things get really worse, we can intervene. So this is an important bill, and as some members have suggested, we need to spend some time on its examination. I hope this bill will be referred to the House Committee as soon as possible, and then we should set up a Bills Committee and deal with another important issue, and that is nowadays the risk in the financial market, international financial market, is really high. So it's important that we handle recovery planning very carefully. Some members are suggesting that rather definitely we are going to see a financial crisis at the end of this year. I don't know why they are so sure, but things are changing fast, so there's no way we can rule out such a possibility. Uncertainty is high, and the things before us are particularly risky. In the U.S., there is a loose cannon president. The relationship, external relationship between the U.S. and other countries looks fine, so far so good. But there are other risks. The DPRK, the nuclear threat. This is the number one concern, and also the capital fraud arising from the DPRK crisis. What would happen if there's a real war? As a major financial hub, or one of the international financial hubs in Asia, Hong Kong will have its banking sector severely impacted on. There was a report yesterday that according to a U.S. think tank, there are people, there are shell companies, 160 of them, using Hong Kong as a channel to launder money for DPRK. If this is real, Hong Kong's banking system will be adversely implicated and affected. So if a select committee is set up, I will certainly raise questions like these. And in the financial sector, where in particular the banks are facing increasing risk because of the use of fintech. This week is the fintech week. The Hong Kong government, SAR government, has been promoting fintech very diligently, but there are changing risks. The risk level may not be increasing all the time, but in recent years we've seen the AI, artificial intelligence, machine learning adding to the risk exposure. In the financial sector, much of these applications have been taken on board. For example, robo-advisor have been utilized. Yesterday, someone asked me who would bear the responsibility if something amiss happened. Would that affect our financial sector in a significant way? I'm from the IT sector. Of course, I support the more extensive application of fintech. In the past, when there was a financial crisis, well, and such crises were mainly due to some hiccups in the computer system and other operations. What should we do in the face of the challenges posed by fintech? Again, these are questions that we should put in a Bills Committee meeting, and that's all. That's why I cannot support Mr. Chu's motion. And with e-banking, we have to look at the risk faced by the banks. The MA has just announced today some new measures. For example, for trade financing, they will use the blockchain platform.
So what will be the implications for the banking sector? I think we need to discuss these issues. With so many risks, Mr. President, I think we should have a thorough discussion. I don't agree with Mr. Eddie Chu's motion. Now, we have been talking about following the tradition of the Council. We should respect Mr. President's ruling, and we're doing a good job on the whole. But, well, please, your time is up. Mr. Lam Cheuk Ting. Mr. President, Mr. Eddie Chu has invoked the rules of procedure 45(4) in opposing the Banking Amendment Bill 2017 being referred to the House Committee for further consideration. I'm afraid I can't agree with his motion. Mr. President, earlier you responded to the Pan Democrats' letter on the amendment of the rules of procedure. You reiterated that we must respect the traditions and customs of this Council. In the past, as a matter of tradition, such bills tabled into the Council would be referred to the House Committee and further referred to a Bills Committee being set up so that members and the administration can discuss the bill thoroughly, and also to seek views from the public, including stakeholders and experts, before tabling into this Council for another debate. If the Bills Committee proposes amendments, it can do so. Individual members, should they oppose the bill, can move amendments as well, and can take that opportunity to convince other members to support his amendments. Lobbying support is an important process. It helps refine the bill, and it also helps us understand more thoroughly the bill in question, with a view to preventing any loophole in that piece of legislation. We do have experience in the past that urgent amendments to the ordinance might be necessary because of unforeseen flaws in the bill which we passed, and we need to respect and follow the convention. About Mr. Chu's motion, I would like to focus on 2 points which support my objection to his motion. Just now, a number of members already mentioned that in the past, this Council also had this experience of invoking Rule 50(4) of the ROP in circumventing the adjournment of the second reading of the bill, and that the bill was read the third time and voted on. But it was only done if the bill involved something of great urgency. Madam Ng, the former Secretary General of the Legislative Council, and in fact Madam Pauline Ng wrote in her book, paragraph 7.08, that in relation to any bill tabled into the Council by the government, before the bill was read for the third time, any member of this Council may move a motion without notice under Rules of Procedure 54(4) to dispense with the requirement of referring the bill to the House Committee for further consideration. If the motion is carried, then the Council may move on to reading the bill for the second time and proceed with a debate on the bill, followed by a committee stage, and then followed by the third reading of the bill. And examples include the Immigration Amendment Bill 1982 and also the Overseas Trust Bank Takeover Bill 1985. So Madam Pauline Ng was very clear in pointing out the usage of 54(4), that is, if the bill should be passed as a matter of urgency. Coming back to those two pieces of legislation, indeed there was great urgency. The first one is the Immigration Amendment Bill 1982, and the background was that there was a sudden influx of Vietnamese boat people into Hong Kong, and we previously adopted quite an open approach in accepting these boat people, and yet we experienced a series of influx of refugees from Vietnam and also other countries. If we did not pass the bill immediately, we would be subject to a very huge burden. Consequently, yes, Mr. Stephen Ho. The point has been raised by many members already. I don't think a repetition would be necessary. Pointing out the relevant bill would suffice. Mr. Lam Cheuk Ting, you elucidated on the point about Vietnamese refugees. Please speak up, Mr. President. I can't hear clearly. You were referring to Vietnamese boat people, but a lot of members already cited this example. As the president of this council, I will try my best to allow members to speak, but please be succinct. There is no need to elaborate in great detail the same point. Thank you for a reminder, Mr. President. I will try to prevent myself from repeating the arguments of other members in a tedious or repetitive manner. So should I continue, Mr. President? The matter was urgent at the time. If the bill were not passed, the stability of our community would be affected. We would face a huge burden. That was why the bill was passed expeditiously. The other example had to do with the Overseas Trust Bank Bill. Mr. Stephen Ho, the OTB Amendment Bill, well, again, I've heard this being cited by members 3 or 4 times already. Mr. President, please rule on this. Well, there is a point of order raised. And let me first explain this. Mr. Lam Cheuk Ting, for the OTB case, many members already spoke on this, and I advised you repeatedly that you need to be succinct. If you go on elaborating on the case, you'll be breaching the rules of procedure. And at the outset, I already reminded members that this debate is about the subsequent procedures for the bill. Please focus on this. Well, Mr. President, first of all, this is the first time I mentioned even the words OTB. I haven't started elaborating on this. I think that for Mr. Ho to accuse me of tedious repetition of the argument, I think is unfair. And also, Rules of Procedure 45(1), it says, who persists in irrelevant or tedious repetition of his own or other members' arguments in the debate. Again, this is the first time I cited this example. Mr. Lam Cheuk-ting, perhaps you weren't paying attention to this debate. At the outset, I already said that when members speak, members should focus on how this bill should be dealt with. So please focus on the Mr. Ediju's motion moved under ROP 45 or 54(4). So please focus on the procedural aspect of the bill. Of course, I understand that, Mr. President, but in order for me to make my point, I need to first explain why I oppose Mr. Ju's motion. We need to cite examples, precedents in this Council in order to support my ground of objection to Mr. Ju's motion. Please allow me to continue. Mr. President, about the urgency of the bill, I just cited two examples, Vietnamese refugees and the OTB case. These two examples exactly explains that ROP 54(4) should only be invoked under extremely urgent circumstances and not in the case of Banking Amendment Bill 2017, which we have now. This bill is extremely important. As Mr. Ronick Chan, representing the banking sector, said in his speech, this bill is highly technical. It is also very important. Mr. President, according to the administration's paper, the object of the bill is to empower the monitoring authority to require authorized institutions to maintain, revise, or implement a recovery plan, which should set out the measures that the institutions can take to stabilize and restore its financial resources and viability in the event that it comes under severe stress, and also to change the limitations on financial exposures incurred by authorized institutions and to empower the monitoring authority to make rules for such limitations. In short, the Hong Kong Monitoring Authority will be empowered to devise a plan such that when there is instability in the banking system, how the banking institutions can be stabilized and how the market as a whole can be stabilized. And also, on the financial exposures incurred by the authorized institutions, how we can limit the exposures. It doesn't only affect the reputations of individual banks. It also affects the stability of the banking sector as a whole. Against the backdrop of globalization, Mr. President, you must know that when a certain bank or company faces some troubles, it doesn't just affect the company itself, but also the whole world. The collapse of Lehman Brothers several years ago caused an unprecedented financial turmoil. That is why, for the Banking Amendment Bill 2017, it carries a huge mission. Should we just read the bill for the third time and for it to be passed just in one day without careful discussion? Shouldn't we allow representatives of the sector, scholars, stakeholders, etc., to engage in a thorough discussion before passing the bill? If the bill is flawed, it could lead to regulatory loopholes, and it could lead to collapse of the banking system. And it may also mar the image of Hong Kong as an international financial center. As one of the members pointed out, the financial sector is one of our major economic pillars, and we must not allow our image to be tarnished.
另一方面，
On the other hand, making the relevant legislation is what Hong Kong should do in order to discharge our responsibility to maintain financial stability. As the paper submitted by the administration says, the Basel Committee on Banking Supervision is assisting the whole world to attain financial and banking stability. The policies are made by this important committee, and as a member of the international community, Hong Kong has an unshakable responsibility to discharge our obligations. Mr. President, Mr. Pt2 invokes ROP 54(4) to attempt to stop the bill from being referred to the House Committee and a Bills Committee, and for the bill to be passed directly by the Council. I think this is hugely unsatisfactory. I also think that we should not set this bad precedent for non-urgent but important bills to be rushed through, because not only the banking sector will stand to lose, Hong Kong people and the international society's financial order and stability will be affected as well. So, Mr. Pt2, sorry, I cannot support your motion. Mr. Leung Yiu-chung. Mr. President, Mr. Pt2 invoked ROP 54(4) to deal with this Banking Amendment Bill 2017. What does it mean? It means that the bill needs not be referred to the House Committee. In his speech, he said his purpose was to make use of the powers given to us by the ROP in order to discuss non-controversial bills with a legislative effect so the banking sector can be modernized in compliance with international obligations. He also said that we should grasp the opportunity to make use of this motion and to give a clear message to the administration so that it knows that the Legislative Council enjoys dignity and that it cannot be manipulated easily. He also points out that there are conventions and also we have the rules of procedure here in LegCo. And that is, for us, we should discuss legislation first. In other words, motions with a legislative effect instead of motions with no legislative effect like the co-location motion. And in the end, he emphasized that the contents of this bill are supported by the banking sector. They do not debate the contents of this bill, and that is why, since there is no controversy, we need not follow the convention and refer the bill to the House Committee. And it is not necessary to set up a Bills Committee to scrutinize the bill. And also, we do not have to follow the convention to refer the bill back to the Council for endorsement. This is his argument. Mr. President, I do not dispute what Mr. Pt2 said in general and also in principle. In fact, at this Council, if you look at the past and the present, we have always invoked the ROP in order to make use of the powers conferred upon us in order to discuss motions and bills. Even last week, we discussed the stamp duty bill. Well, there were controversies and also there were places without controversies. And then the administration also made use of the powers in the ROP in order to retract the bill. So I agree with him in invoking the ROP. And he said that we should grasp the opportunity so a clear message is sent to the administration through this motion that the Legislative Council has dignity and it cannot be easily manipulated. Mr. President, this is a message given to the administration that this council has dignity. But to me, I don't think we can achieve that purpose just by going through this procedure. In order to preserve dignity for this council, we cannot do so just through moving this motion. We should all abide by and comply with the ROP. And Mr. President, you and ourselves should act according to the ROP. And we should pass bills so that society is protected by legislation. This is where the dignity of the council lies. The message has always been there. It is not just for the administration, but for the public. So why is it that today we can achieve this purpose only by invoking ROP 54(4)? I have doubts about that. He also emphasized that the administration should not be allowed to casually manipulate the council and the ROP. Well, but to me, unless the administration will tell me that it had not followed the ROP or is not following the ROP, or that the president, when he presided over meetings and when he approved bills or motions, that he departed from the ROP. Otherwise, I cannot say easily that the administration manipulated the ROP unless Mr. Pt2 can point it out. Mr. Holden Chow, a point of order. Mr. Leung Yiu-chung has digressed for quite some time. Please ask him to come back to the motion. Mr. Leung Yiu-chung, can you come back to the motion? Mr. President, and that is how we should deal with the remaining procedures for the bill. Mr. Pt2, a quorum count first. No, there is a quorum here in council. Mr. Leung Yiu-chung, please continue. Mr. President, can I ask you to clarify? Because I am speaking on the motion of Mr. Pt2. Why is it that I have digressed? I have been quoting him. That is what he said in moving his motion. So whether I agree or disagree with the motion, I, of course, should be able to quote what he said and then comment on it. I can comment on his position, can't I? Why have I digressed? Mr. Pt2, I'd like to ask for a quorum count. There is a quorum. Mr. Leung Yiu-chung. Mr. Leung Yiu-chung, please continue. Members, order, please. Mr. Leung Yiu-chung. Was it Mr. Holden Chow? He said that I digressed. How had I digressed? Mr. Leung Yiu-chung, I reminded members time and again that you should speak on the remaining procedures for dealing with the bill. Please continue. Mr. President, I was exactly speaking on how we should deal with the bill, and I was speaking on whether I agree or disagree with Mr. Eddie Chu's motion, and he was talking about the remaining procedures of the bill. He said that he did not agree that the bill should be referred back to council, and I was speaking on his motion. How wrong was I? Unless you are saying that Mr. Eddie Chu should not have said what he said. Well, he said what he said, and there is already a record. But he said what he said, and you did not stop him, and I was speaking on what he said to comment whether I agree or disagree with him. Mr. Leung Yiu-chung, please come back to this debate and continue to speak. What I'm saying is, if he has the chance to, Mr. Eddie Chu should say in his reply and quote concrete examples how the administration has manipulated procedures and did not follow conventions. I hope he would quote facts for my benefit. He emphasized that there was no need to refer to the bill to the House Committee. As I said, he said that the banking sector did not find the bill controversial, so we did not have to follow conventions. Mr. President, I like to say that surely the target of the bill is the banking sector. Say, for example, what does the bill say? It says there will be preventive measures to deal with financial exposure, and that is to implement a recovery planning, and that is to prevent banking or financial institutions from collapse. If the institutions cannot continue but collapse, then this will not be affecting the banking sector only. This is related to the administration as well as the public. Why am I saying that? Because, let me give you an example. I hope when other members hear this, don't say it has been quoted so I cannot quote it, because I am using a different perspective in quoting this example. In 1985, on the 6th of June, the administration ordered that the OTB be asked to stop its operation. And then the next day, well, actually, on the same evening, a statement was issued saying that the Commercial Crime Bureau had started to investigate into the operation of the OTB, and then the next day, 3 readings were done on the bill, and it used $2.1 billion from the exchange fund to take over the OTB. So this is not just about the urgency of the matter. And what I'm saying is there is an impact on society when a bank collapsed. At that time, the administration made use of $2.1 billion from the exchange fund to take over OTB. My question is, now what is the purpose of this bill? As I said, it is for preventing collapse of financial institutions which could not continue to operate. Now, when you say the banking sector has come to a consensus, well, at least Mr. Eddie Chu said, so we did not have to follow the procedures. But then this is also going to affect the public. So why we don't give the opportunity to the public to express their views? I think that is extremely important. And not only that, President, I hope you will not say that I'm repeating other members. This bill empowers the monetary authority to make subsidiary legislation to change the limitations on financial exposures. This is very important. Now, whether the rules or legislation to be made is lenient or severe, there is also an impact on the public, because the public may have or may not have confidence in these institutions. I think this is such a serious issue. We should have more time and more discussion, or else the impact would be far-reaching. So on this point, we should not only talk about whether the banking sector finds this bill problematic or whether they support the bill. I think what is more important is for the public to be able to express their views. In addition, as the Secretary said, when the institutions are under severe stress, there should be recovery planning so as to allow institutions to continue with its operation. What does that say? It points to the actual operation of the banking institutions.
If
you only heed the aspiration of the industry, is it fair to the public? Are we going to address the problems? Is it reasonable to the community? Is it good for social progress? There are a lot of unanswered questions. So when Mr. Chu speaks again, I hope he would elaborate on his arguments. He's stressing the point that because of the consensus in the industry, some of the procedures that we adopted in the past should not be carried out. Have you also listened to the public? If so, how are you able to take on board public opinion, which is equally important? All these questions have to be answered by Mr. Chu. In your first speech, you buried a touch on these points. And also, there are a lot of issues that we need to look into. For example, empower. We are going to empower the monetary authority to come up with subsidiary legislation to set the financial exposure limits. When it comes to the MA or the presidents, very often they are given great powers, and that lead to a possibility of abuse of power, and therefore powers are not exercised properly. For example, the Commissioner of ICAC is given so much power that even the UGL incident of Mr. C.Y. Leung is not properly looked into. So we have to prevent abuse of power. When it comes to prevention of abuse of power, we need to spend a lot of time, spend much time on a discussion to prevent it. So in dealing with this Banking Amendment Bill 2017, we should adhere. Members, please return to your seats and please keep quiet. The matter should be referred back, the bill should be referred back to the House Committee instead of proceeding to the second reading and third reading hastily. The Council meeting is adjourned until 9 a.m. tomorrow.